Over the years, as a master code professional and a building codes administrator, I've developed PowerPoint presentations for permit technicians. That's what these videos are all about. They will help permit technicians either preparing for the ICC exam or just for professional development. And we encourage you to participate in that. You will have two modules on this. We're going to cover three subjects with the first, three with the remaining. Then we're going to have another training video out there with just a practice quiz. And we'll also have some information on the ICC exams. We encourage you to go to the description and purchase all the code books that you're going to need for your exam and also for your training. We also ask that you please subscribe and like to these videos.
The professional staff at the Building Code Administration Office must understand the principles of constitutional law as they affect the daily administration and enforcement of building codes before resorting to forceful measures. Always seek the advice of the municipal attorney before forceful or legal action is taken. Whenever the building code requires notice to a party, notice must be given by the building official before a charge can be brought. It is a condition precedent, and any charge filed without the proper notice is subject to a motion to dismiss. It also serves common sense. How can the citizen correct a violation that they do not know about or understand the needs for correcting? The notice must contain each element required by the code provision, usually the name of the responsible party, the location of the property, the nature of the violation, and a deadline for correction and notice of the defendant's right to appeal. The notice must be served in a manner that complies with the code, whether it is certified mail, personal service, or posting. Notice of violation is covered in the IBC and provides that the building official is authorized to serve a notice of violation or order on the person responsible for the erection, construction, alteration, extension, repair, moving, removal, demolition, or occupancy of a building or structure that is in violation of the provisions of the IBC or in violation of a permit or certificate issued under the code. The order must direct the discontinuance of the illegal act or condition and the abatement of the violation. The I-codes also provide building officials the authority to halt construction activity immediately if deemed necessary. Building officials have the authority to stop work until code violations or other hazards to the public safety have been resolved. If, during the inspection process, it is found that the work is not going according to the plan submitted, the building official may wish to take summary action to revoke the permit or to issue a stop work order. Issuing the stop work order is the recommended first procedure. A stop work order is immediate action taken to abate a violation without formal court proceedings. Stop work orders are authorized by the IBC. A stop work order shall be in writing. It shall be provided to the owner or the owner's agent. It shall cite the work that must immediately cease. The order shall state the reasons and the conditions under which the cited work will be permitted to resume. The order must provide further direction for due process. Before issuing the stop work order, it would be suggested that the building official and contractor or owner meet first. And remember, all communication may become part of a legal record in future proceedings. After other administrative relief options are exhausted, an injunction may be sought by the building official. The remedy is, in essence, an order of the court which requires that the defendant cease and desist from all conduct that amounts to a violation of the building code. In almost every jurisdiction in the United States today, injunctive relief is broken into three types: a temporary restraining order, a temporary or preliminary injunction, and a permanent injunction. A temporary restraining order is an order issued by the court without notice to the other party and without an opportunity for the party to be heard. A temporary injunction is a judicial order that is issued pending a full hearing by the court. And a permanent injunction is a judicial order that is issued after the court has heard all the evidence in the case. The factual circumstances and legal standards that must be met in order to receive a temporary restraining order or a temporary injunction should generally be known by the building official so that an educated decision can be made whether to seek either. Both the temporary restraining order and the temporary injunction are usually subject to 4 legal requirements. First, the building official seeking the injunction must show that there is a significant threat of irreparable harm to the public if the injunction is not granted. Second, the building official must show that the harm the public would suffer if the injunction is not granted is greater than the harm that the other party would suffer if the injunction is granted. Third, the building official must show probable cause that he or she will prevail on the legal merits of the controversy. And fourth, the building official must demonstrate that the issuance of the restraining order or injunction is in the public interest. A significant portion of time is spent by building code departments responding to complaints regarding parcels of property. Some general guidelines relating to handling those complaints may be useful. First of all, the person who receives the complaint should obtain as much information as possible: the name of the complainant, his or her address, phone number, the date that he or she viewed the alleged violation, and the nature of the alleged violation are all important. It is also important for the person who handles the complaint to realize that the job of the Codes Department is made easier when the citizenry of the jurisdiction cooperates. Once a violation has been found, some action must be taken to enforce the code. Ordinarily, if the structure has been completed, the summary procedures of the revocation of a permit or issue of a stop work order are not available. Once the construction has been completed, prosecution in the city courts becomes the final method of enforcement. In most jurisdictions, a civil or quasi-criminal complaint may be filed against the owner or occupant of the property. Normally, with a civil complaint, the notice of violation may be served either through the mail or physically delivered to the alleged offender. In some jurisdictions, an alleged offender is still required to be arrested under an arrest warrant. A typical complaint in most jurisdictions will contain 6 elements. The first being the name of the person or entity. The first decision that must be made when a complaint is prepared is who is the party to be charged. Answering this question correctly will prevent lawsuits for false arrest. Designating the charge. Every complaint must contain the section number and the name of the violation. Body of the charge. Every ticket must contain a description of the violation which is sufficient so that the defendant can defend against the charge and to make sure he or she is not charged twice for the same offense. Date and time of offense. Each complaint must contain an allegation regarding the date and time of the offense. For ordinance violations, the date must fall within the statute of limitations. Signature of the complaining witness. Each complaint must be signed by an individual, either an inspector or a witness. Finally, number 6, notary or affidavit. Depending on the jurisdiction, a complaint may need to be verified by the person signing it, that is, sworn to under oath that the information contained therein is true and correct. The Board of Appeals. This board is known by various names, and there are a variety of different tribunals covering different parts of the building process. The Board of Appeals can be known as the Construction Board of Appeals, the Zoning Board of Appeals, or other names as deemed necessary in your jurisdiction. Quite often, the Construction and the Zoning Board of Appeals will be the same members. The Board of Appeals derives its power from the building code through which it was created. The IBC includes a section dealing with the Board of Appeals. The Board of Appeals shall be appointed by the governing body and shall hold office at its pleasure. The board adopts policies and procedures for conducting its business. It is important to note, to have these boards of appeals in place with members appointed is critical, even if they only exist on paper. All too frequently, a defendant may seek an appeal and the municipality scrambles to create a board for that purpose. If a board of appeals exists in an ordinance, it should exist in reality. The Board of Appeals is created by the Building Code. The members are appointed by the legislative body, qualified by experience and training. The Board of Appeals has no authority to waive requirements of the Code. 112.2 of the IBC lists the conditions where an appeal is allowed. Number 1, the true intent of the code or the rules legally adopted has been incorrectly interpreted, or the provisions do not fully apply. Lastly, an equally good or better form of construction is proposed. To repeat, the Board of Appeals shall not have authority to waive requirements of this code, IBC Section 113. The Board of Appeals, in one of its first actions, shall adopt their rules of procedure. One of the most basic procedures a board may establish in the adoption of rules of procedure are for those who come before it. These rules need not be complex. It is best to develop a set of rules which reflects the board's current practices and procedure. To make the rules official, there is usually a legal requirement that municipal boards file their rules of procedure with some central office. One of the first things to establish in any set of rules and regulations for the board is that meetings be open to the public. When the open public meeting laws have been enacted in the various states across the country in the last 20 years, it is imperative that most boards keep meetings open to the members of the public at large so they may come in and watch. The notice requirement is one of the most crucial requirements in the appeals process. In order for an appellant to get a fair hearing in front of the Board of Appeals, he or she must be informed of the time and place of the hearing within a reasonable amount of time before the hearing takes place. In other words, it would be insufficient notice to inform someone of a hearing the day before the hearing was scheduled to take place. Appellants must be given an adequate amount of time to prepare their materials and argument. Notice is a key component of due process, as discussed earlier in this program. To review, procedural due process is based upon the constitutional right to notice an opportunity to be heard at a meaningful time and manner, and usually prior to deprivation of property, permit revocation, or demolition of property. There are emergency exceptions that exist. A claimant filing an action directly with the courts without having first brought the issue before the Board of Appeals may be found in violation of the administrative due process. The International Building Code requires that every order of a Board of Building Code Appeals be handed down in writing with copies to the building official and the appellant. Whether a revocation, suspension, denial, or other order, all communication should be carefully presented in a written statement from the permitting authority to the applicants to allow for legal due process. Courts that review Board of Appeal decisions usually employ the substantial evidence standard. This standard provides that if a reasonable person could think that the board's decision was based on evidence sufficient to prove the issue in question, the reviewing court will accept and affirm the board's decision. Most courts will defer to the administrative officials in the interpretation of a building code. This means that the courts will also defer to the decisions of the Board of Appeals, as long as the Board of Appeal decision was not made in an arbitrary or capricious manner. The courts will uphold its ruling. A decision would be found arbitrary or capricious if it were made without relevance or either the law or the facts. If the board is at all unsure about the legality of its rulings, it should consult the municipal attorney. The court system relies generally on two types of review, a de novo hearing and one based on the record before the administrative tribunal. A de novo hearing is one in which the whole hearing is reheld in front of the court. The court disregards the facts collected in front of the administrative tribunal and gathers its own facts. Similar to processes for building permits, if a zoning request does not comply with the zoning ordinance, the request will be denied. The applicant will have the right to appeal that decision to a zoning board of appeals. Referencing the International Zoning Code, interpretations. The interpretations and application of the provisions of this code shall be by the code official. Typically, when there is a conflict between the building code and the zoning ordinance, the most stringent requirement is enforced. An appeal of an interpretation shall be submitted to the Board of Appeals. As mentioned earlier, we have different names for the same board. In the zoning code, it's the Board of Adjustments and Appeals. Members shall be residents of the jurisdiction served. They are appointed by and answer to and report to the city or county council, the legislative body. They shall hear and decide on appeals of decisions of the code official. They shall hear and decide on appeals wherein a variance is proposed. All decisions must be based on the spirit and intent of the code and not constitute granting of a special privilege. The Board of Adjustments and Appeals shall have the power to hear and decide on appeals wherein a variance to the terms of the zoning code is proposed. They shall be permitted to approve with conditions, or deny a request for a variance. They shall not grant a variance to allow the establishment of a use in a zoning district when such use is prohibited by the provisions of the zoning code, and they shall not have the authority to alter or change the code. They shall hear and decide on appeals where it is alleged that there is an error in the interpretation. Within the text of the International Zoning Code are provisions that allow for inequities. These include a variance. A variance is an easing of the terms of the zoning ordinance. A zoning variance provides property owners with legal permission to use their land and build structures that would otherwise contradict the local zoning laws. Variances do not change the zoning of the property. It merely allows the landowner to use the land in ways that would not usually be permitted. Variances are not typically granted unless the property owner can show that the existing regulations present a real difficulty in using the property. Use and area are the two most common types of variance granted. This listing is from the International Zoning Code. The Basic Code Enforcement Handbook lists 4 issues in Chapter 3. If you are taking the ICC exam, you are advised to look closely at the questions to determine which would be applicable and the correct reference to use. We recommend using the zoning code as a default. To qualify for a variance, an applicant has the burden of proof to demonstrate compliance with the following criteria. 1. Limitations due to physical, topographical, and geologic features. 2. The request for the variance will not grant special privilege to the property owner. 3. Without a variance, there can be no reasonable use of the property. 4. The variance request is not based solely on economic reasons. 5. The issue is not created by the property owner. 6. The variance will be the minimum variance necessary to allow reasonable use. 7. The variance request is not to be injurious to the public health, safety, and welfare. And 8. Property subject to the variance request possesses one or more very unique characteristics. The building department, by virtue of its function as a regulatory agency, is subject to legal attack at any time. Refusal to issue a permit, revocation of a permit, imposition of requirements, failure to perform an act, refusal to allow occupancy, or any of a host of other reasons can bring legal action against the building department, the community, the building official, and the department staff. A review of case law relevant to the Department of Building Safety follows. Building officials are involved with the legal aspects of code administration in 2 main ways: administration and enforcement. Through administration of code, building officials serve as the thresholds to public safety in the built environment, operating the legal processes necessary for the permitted construction, use, and occupancy of buildings and structures. Through enforcement of code, building officials serve as law enforcement officers, requiring compliance with code through procedures defined by legal due process. When moving forward with any enforcement activity, code officers and inspectors should be sure to know the limits of your authority. Be in a place you have the right to be. Inspect for conditions that violate the code, and refer those conditions outside of your scope to those who have the authority. Conducting inspections and the Fourth Amendment. The Fourth Amendment of the U.S. Constitution prohibits unreasonable searches and seizures. This applies to a code official inspecting a private property, as that inspection constitutes a governmental search. A code inspection is a reasonable search if it is conducted in accordance with the legislative standards. The easiest way for a building official to conduct a lawful inspection is to obtain the consent of the proper person. The plain view doctrine, an exception to the Fourth Amendment's warrant requirements. If there is any legal concept or practice that is helpful to regulatory inspectors and officers, it is the plain view doctrine. Basically, under the plain view doctrine, if code officials are lawfully in a position from which to view an object, if it is visibly a violation of the locally adopted code or ordinance, they may issue official warnings, notices of violation, or citations regarding the violation without a warrant. General consent considerations. Consent must be given freely by someone with authority of suitable age and discretion. It may be limited and it may be withdrawn. It does not authorize general entry of other agencies lacking legal rights. It allows you to report what you find to all appropriate other authorities. Code provisions often require inspection. If possible, always seek entry by consent. Cooperative compliance is always preferable. A building official must understand that the building code can never authorize an unconstitutional inspection. In spite of the fact that virtually every housing and building code enacted across this country contains a provision permitting inspections to be carried out in the line of duty, these provisions do not allow the building official to inspect someone's property in a manner which contravenes the mandates of the Constitution. The first and most important case in this field established that principle. In Camara versus Municipal Court of the City and County of San Francisco, a city housing inspector came to the lessee's apartment complex to perform a routine inspection. Upon arrival, he was told by the owner of the complex that the lessee of the ground floor was using the rear of the leasehold as a personal residence. The inspector determined that the occupancy permit did not allow residential use of that floor and demanded that the lessee consent to an inspection. The lessee refused, claiming that the inspector did not have a search warrant. A few days later, the inspector returned to the apartment without a warrant and asked again to be permitted entry in order to inspect the ground floor. Again, entry was refused. A short time thereafter, Camara was criminally charged with refusing to permit a lawful inspection and was arrested. The trial court sided with the city against Camara by finding that the mandatory inspection provisions of the San Francisco City Code was not contrary to the Fourth Amendment. This decision was affirmed by a California appellate court. Camara once again appealed the decision to the Supreme Court, which agreed to hear the case. The court began its analysis by stating the fundamental premise that a search of a private property is unreasonable unless consented to or authorized by a search warrant. It then addressed each of the city's three arguments in favor of carving out an exception to that rule in the case of municipal health and safety codes. The final decision by the U.S. Supreme Court determined that if the occupant, it need not be the owner, of a residential structure does not consent to an inspection, a warrant must be obtained in order to legally gain entry into the premises. And an occupant who does not consent to an inspection cannot be prosecuted for a violation of a law requiring obedience to the order of the municipal official. In the Tennessee case of Jackson versus Davis, two co-owners sued, among other defendants, two building inspection officials for an alleged Fourth Amendment violation. Specifically, the tenants of the residential structure, fearing that our electrical wiring was faulty, asked for an inspection of the electrical system. After examining the premises, the inspectors found a defective wiring system that made the residence unsafe and dangerous to human life. After the tenants moved out, the inspectors had the electricity disconnected. The trial court found that the inspector's search of the property was not in violation of the Fourth Amendment. It reasoned that once the premises had been rented to the tenants, those tenants were the only people who had an expectation of privacy. This expectation lasts for the duration of the tenant's lease. During that time period, the tenants were the only parties who had a legitimate expectation of privacy in the property. By requesting the inspection of the electrical system, the tenants had given their consent and thereby waived their Fourth Amendment rights. In spite of this decision, the building official should still exercise caution when entering a building without a warrant. In the Jackson case, the court found that the tenants had an exclusive right of occupancy and use of the building. In some situations, however, a tenant may not have such rights to the entire building. The building code official should always question the occupant in a detailed fashion about his or her rights to the property. Even if it seems clear that the occupant has total control over the entire premises, it is always better to err on the side of caution. In Cranwell v. Metz, a Washington case, the court agreed with the Jackson decision and extended its holding to allow a tenant to consent to a search of the common areas of an apartment building, such as the laundry room, the hallways, and the entryway. Cranwell also stated that a tenant's consent to search both his or her private apartment and the common areas of the apartment structure will override any explicit written refusal of consent on the part of an owner. The U.S. Supreme Court held in Illinois v. Rodriguez that an officer may rely on a person who acts like he or she has authority to consent to the search, but in fact does not. In that case, the defendant's girlfriend consented to the search of their apartment, even though she had already moved out. The evidence seized was not suppressed because the officer's belief that the girlfriend had the authority and it was reasonable. Key points concerning the Fourth Amendment is the plain view doctrine, the exceptions in emergency situations. We will see the case of Michigan versus Tyler in the next slide. Heavily regulated businesses. For certain types of businesses, inspections are allowed without a warrant. Frey versus Panza. Reasonable expectation of privacy. Always get consent when you can. When in doubt, get a warrant. In an emergency situation, a warrant may not be necessary, as found by a court. These cases can involve fire, flood, severe weather, a situation in which there is no time to gain a warrant. These are considered exigent circumstances. But be mindful, the courts consider businesses and residences differently when the conditions of exigent circumstances apply. Emergency situations constitute another exception to the Fourth Amendment's general warrant requirements. Emergency situations were addressed by the United States Supreme Court in 1978 in the case of Michigan versus Tyler. In 1970, a furniture warehouse fire, later determined to be arson, was first investigated the night of the fire and then the next day. And then the investigators returned 30 days later. All inspections or investigations were conducted without a warrant. Tyler, the lessee of the property, was arrested and convicted of arson. The conviction was reversed by the highest court of the state of Michigan because of a lack of a search warrant, and the case was appealed to the state Supreme Court. The Supreme Court determined that the warrantless intrusion in this situation was unconstitutional. The emergency was over. The officials had ample time within which to obtain a search warrant, and failure to do so violated the Fourth Amendment. In Michigan versus Clifford, a private residence was damaged by fire while the owners were out of town. The blaze was extinguished and the firefighters and the police left the premises. 5 hours later, arson investigators arrived and found a work crew boarding up the house at the request of the homeowner. Without a warrant, the investigators entered the property and found evidence of arson. The owners were charged with arson. In their defense, they moved to suppress all evidence against them on the basis that it had been obtained illegally. The courts held the following. The evidence obtained by the arson investigators was gathered in violation of the Fourth Amendment and had to be suppressed. There is a strong expectation of privacy in property used as a residence. Hence, the owners in this case retained significant privacy interest in their home. Without consent or exigent circumstances, the investigators needed a search warrant because the search was unreasonable. The court decided that an administrative search warrant is sufficient if the purpose of the search is to search for the cause of the fire. However, if the purpose of the search is to obtain evidence of arson, a criminal search warrant is necessary. An emergency situation is considered an exigent circumstance, but the exigency ends upon elimination of the danger. Once the emergency dissipates, the warrantless entry is no longer justified. Heavily regulated businesses. For the building official, this may be the most important exception to the Fourth Amendment's general warrant requirements. The Supreme Court has frequently observed that in particular types of industries, inspections without warrants are constitutionally acceptable. In determining if a warrantless search of a business is allowed, the court will consider whether the business has a history of being closely regulated, whether there is a substantial interest by the state, whether the regulation serves a substantial interest, whether a warrantless search is necessary, and whether the statute has an adequate substitute for a search warrant regarding notice and the scope of the search. The Third Circuit Court has held that the construction industry is one such regulated business. In Fry v. Panza, Darrell Fry, a home builder, on March 1, 1977, was in possession of a number of properties upon which he was constructing homes. The building official, inspector, Mr. Panza, would come by the site and conduct random inspections without his request. Fry sued Panza and the jurisdiction, claiming a 1983 constitutional violation, charging that the defendants' warrantless and unconsented inspections of these incomplete structures had violated his Fourth Amendment rights. The district court entered an order on November 2, 1977, dismissing the complaint on the grounds that no case had been called to its attention in which a court had extended Fourth Amendment protection to uncompleted and unoccupied structures. The right of the code official to inspect on an open permit has a regulatory exception to the warrant requirement. Since there is an increased governmental interest in public safety during a building project to see it is being done safely and to code, and a decreased individual right of privacy prior to any occupancy. Inspection rights can be incorporated by specific language in the permit as a condition of the issuance and the viability of a building permit, with the applicant consenting to such inspection by making and signing the application. Some key items in the Fifth Amendment review. The Fifth Amendment is where you find the takings clause. Case law includes Doles versus City of Tigard. The Fifth Amendment's language, nor shall private property be taken for public use without just compensation, as well as the due process clause of the 14th Amendment. In Doles versus the City of Tigard, Doles owned a commercial property which had been declared a non-conforming use. Doles wanted to extend that non-conforming use. Doles also owned on that same property access to a waterway. The City of Tigard approached Doles and said they would allow him to extend the non-conforming use if he would grant the city a portion of that waterway property for the city and the enjoyment of all the occupants of the city. Doles sued. The result was that when a government authority attaches a condition to a building permit, the burden on the property owner must be roughly proportionate to the benefits for the government. The city's dedication requirements constituted an uncompensated taking of property, a Fifth Amendment violation. The court held that under the doctrine of unconstitutional conditions, a government agency may not require a person to surrender constitutional rights in exchange for discretionary benefits, where the property sought has little or no relationship to the benefit being conferred. Following up on Doles versus City of Tigard, several years ago, the Supreme Court developed a test which can help a municipality determine whether or not its easement requirements constitute a takings under the Fifth Amendment. In Dolan versus the City of Tigard, the court outlined the rough proportionality test. Under this test, no precise mathematical calculation is required to determine what constitutes a taking. Rather, the city or municipality must make some sort of individualized determination that the land required to be dedicated to public or governmental use, as set out in the ordinance, is related both in nature and extent to the impact of the proposed development. Although this test is more exact than others that have come before it, applying it to particular facts has apparently caused its share of confusion. As of 1975, the court has refused to refine or elaborate on the test. In a case that involved both estoppel and vested rights, Doles Enterprises in the city of Troy, Illinois, was a developer who bought land based upon an assurance from the city that the property was zoned R2. Their intention was to build multifamily housing complexes. The city issued building permits for the multifamily housing complex. The city soon determined that the land was actually zoned R3. The city revoked the permit and issued a stop work order. At the time, the project was 70% complete. The developer sued. The court held in favor of the developer on the case. After applying the requirements set forth in law and the facts of the case, the court determined that the plaintiff expressly conditioned its purchase of the land upon it being zoned for multifamily housing dwellings, and it was more than reasonable to assume that the plaintiff would rely upon the representations of the city clerk and the building inspector when it began to build upon the land. In fact, the court concluded that the city induced the plaintiff to purchase the land. It held that an injunction was necessary to avoid the irreparable injury that would befall the plaintiff if the city was allowed to enforce a stop work order. Recent court actions have found that a permit issued in error may still be revoked, but the cost of the mistake should fall upon the entity who negligently issued the permit. Keynotes concerning the 10th Amendment of the U.S. Constitution. The powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively and to the people. This is where we find the police powers in the 10th Amendment. Key concepts of the 14th Amendment. This is the Equal Protection Clause. No state shall deny to any person within its jurisdiction the equal protection of the laws. The Equal Protection Clause applies to building codes in two ways. Number one, the code applies to people and buildings that are similarly situated in substantially similar ways. Number two, prohibits discriminatory enforcement of the code. Two concepts, facial validity and discriminatory enforcement. The Equal Protection Clause prohibits discriminatory enforcement of the code. Discriminatory enforcement does not look at the facial validity of the law, but rather on how the law is applied. When an individual who is found in violation of a building code raises the defense of discriminatory enforcement, he or she is claiming they are being singled out for enforcement. In the classic case of Wu versus Hopkins, a San Francisco ordinance barred the operation of hand laundries in wooden buildings, except by consent of the Board of Supervisors. In practice, the board denied all applicants of Chinese origin while granting permits to all but one of the non-Chinese applicants. The court held that although the ordinance has facial validity, it was administered in a discriminatory manner. The builder or developer challenging a provision of a local building code bears a heavy burden. First of all, the courts will ordinarily presume that the law is constitutional. That is, without compelling proof to the contrary, the court will uphold the legislative enactment. In an example, we have Eggert versus Board of Appeals of the City of Chicago. An owner of an existing wood frame structure challenged the constitutionality of a law which prohibited any more than 4 dwelling units in a building of wood frame construction. The court upheld the law. The court understood from this record that the purpose of the legislation was to protect against fires and to minimize the danger that would be done if one were to start. This purpose was legitimate, and the court felt the means to reach it were reasonable. Until the early 1960s, federal, state, and local governments were almost completely unaffected by civil rights legislation. In 1961 and the years following, the Supreme Court began to interpret heretofore untapped legislation that provided cause of action for people who suffered civil rights violations at the hands of the government. Section 1983 is a cause of action under which a state or local government can be held liable for money damages and declaratory relief for violating the Constitution or laws of the United States while acting under the color of state law. Some commentators have declared that no statute is more important in contemporary America than Section 1983. Nevertheless, before 1961, the Civil Rights Act of 1871 was rarely invoked. Within the last 30 years, this statute has become the basis for almost all constitutional rulings arising from the actions of state and local government. Section 1988, the Attorney's Fee Award Act, is one of the most important innovations in civil rights litigation. This act allows the plaintiff to recover any expenses incurred for attorney fees in the prosecution of the case. Therefore, if a defendant loses a Section 1983 lawsuit, the defendant may face payment not only of the actual compensatory damages awarded to the plaintiff, but of the attorney fees as well. In 1990, Congress continued its intervention in both the private and public sectors on behalf of disabled persons with its adoption of the wide-ranging Americans with Disabilities Act. This act covers employment discrimination, public transportation, public accommodations, and telecommunications. The latest edition of ICC's ANSI A117.1, Accessible and Usable Buildings and Facilities, may be the only accessibility laws in effect in many jurisdictions. This does not negate the responsibility for compliance by the owner of the Americans with Disabilities Act. Additional accessibility laws that must be considered and their enforcement entities will include the Americans with Disabilities Act, published and enforced by the U.S. Department of Justice, and the Fair Housing Act, amendments in 1988, published and enforced by the U.S. Department of Housing and Urban Development. The Equal Employment Opportunities Commission issued 2 regulations to enforce the provisions of Title I of the Americans with Disabilities Act on June 26, 1991. The provisions took effect on July 26, 1992, and covered employers with 25 or more employees. That was reduced to 15 employees on July 26, 1994. Before we begin our review of the Equal Employment Opportunity Act, we want to note that the application and interpretation of relevant federal statutes changes from time to time based in part on case law. Building officials should always consult qualified counsel in applying EEOC or any other legal standards in personnel administration. The Pregnancy Discrimination Act is an amendment to Title VII of the Civil Rights Act of 1964. Discrimination on the basis of pregnancy, childbirth, or related medical conditions constitutes unlawful sex discrimination under Title VII. Key components of the Act include the following. Employers must hold open a job for a pregnancy-related absence the same length of time jobs are held open for employees on sick or disability leave. They cannot discriminate, and they must make reasonable accommodations. Sexual harassment is a form of sex discrimination that violates Title VII of the Civil Rights Act of 1964. Unwelcome sexual advances, requests for sexual favors, and other verbal or physical contact of a sexual nature constitute sexual harassment when submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. Title I of the Americans with Disabilities Act of 1990, which took effect July 26, 1992, prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other terms, conditions, and privileges of employment. Title VII of the Civil Rights Act of 1964 protects individuals against employment discrimination on the basis of national origin as well as race, color, religion, and sex. A rule requiring employees to speak only English at all times on the job may violate Title VII unless an employer shows it is necessary for conducting business. The Immigration Reform and Control Act of 1986 requires employers to prove employees hired after November 6, 1986 are legally authorized to work in the United States. The Fair Housing Act of 1968. In recent years, there has been much attention paid to the millions of American citizens with some sort of physical or mental disability. In 1988, Congress amended the Fair Housing Act of 1968 to extend its protection to handicapped persons. A handicap was defined as a physical or mental impairment which substantially limits one or more of the person's major life activities. The goal of the amendment is to overcome the stereotype that people with disabilities cannot function in normal surroundings and therefore need to live elsewhere. This act is of importance to the building code official because it mandates design standards for new housing with 4 or more units. These standards are meant to ensure general access both around common areas and within the units themselves. Some of the many requirements designers and builders of structures of more than 4 units must follow are: number 1, doors, halls, and thresholds must accommodate wheelchairs. 2, light switches, electrical outlets, thermostats, and other environmental controls must also be accessible to people in wheelchairs. And 3, usable kitchens and bathrooms must be built so that wheelchairs can move about in the space. Let's review some definitions. Abusive process. A person who is found liable for abusive process is someone who has used the legal process as a threat to get something unrelated to the litigation. Absolute immunity. A policy of protecting public officials from tort liability. Assault, the willful attempt or threat to impose injury upon another. Battery, an intentional infliction of harmful or offensive bodily contact. Caveat emptor, let the buyer beware. Caveat venditor, let the seller beware. Censori, a writ of common law issued by a Supreme Court. Contributory negligence, doctrine that holds that the plaintiff has been guilty of any negligence which has contributed to his injuries or damage, then he is totally barred from any recovery. De novo, a hearing that is reheld in front of the court. To continue, immunity, a legal privilege that prevents liability from attaching to the actions of certain individuals. It may be absolute or qualified. Liability, an obligation that one is bound in law or justice to perform. Lis pendens, legal proceedings which may be pending in court affecting the title or ownership of property. Owner persona, a person who is the owner of any fixed property or fixtures. Per se means in itself. Respondent superior, a doctrine that states that the master or employer is liable for the wrongful acts of his servant or employee. Ultra vires literally means beyond the powers. Voir dire, literally to speak the truth, typically in qualifying jurors.
Remember to subscribe, like, and support these efforts that we're having for you, and we wish you the very best of luck in your professional development.